Hello, this is Elana Zeide.
Hi, Elana. I hear you.
Yes.
All right. You're going to want to click on share your screen.
Okay. Give me one moment to do that. Okay. Share my screen. Okay.
Perfect.
Did it
That'll
work?
work. Yes, I see it. Go ahead and go through a slide just so I can make sure. Yes, perfect. All right, and we're going to get started in just a minute. I'll do an introduction and then turn it over to you.
Excellent.
All right, perfect. Go ahead and leave up the slide. All right, perfect. We'll get started in just a minute. Good afternoon. We're going to get started in just a minute. Good afternoon. We're going to get started in just one more minute. Thank you. All right, good afternoon to everyone, and thank you so much for joining our webinar today on the Fair Information Practice Principles and how they apply in education. I am absolutely thrilled to have student privacy expert and my very good friend, Elana Zeide, presenting today on the FIPPs. She's done an extensive amount of work on education privacy in general, has specifically written a law review article about how the FIPPs may not be the best approach when dealing with student privacy, and I'm really excited for her to dig in for all of you today. In case you didn't already notice, the webinar today is being recorded, so we can share it with other post-sec data folks later. So just be aware of that. Questions can be entered in the chat box throughout the presentation, but we'll get to all questions most likely at the end. So with that, I am going to now turn things over to Elana.
Excellent. Can everyone hear me?
Yes, we can hear you.
Fantastic. Thanks for the introduction. I'm here today to talk to you about the Fair Information Practice Principles and how they were created, what concerns prompted them, how they're relevant today, and how they can be incorporated into institutional practices or legal measures in ways that help address the concerns that originally animated them and still animate them today. So here are the Fair Information Practice Principles, broadly speaking. They're generally referred to as the FIPPs, and there isn't one specific consensus about what they actually are, but they generally have some combination of the things you see on the screen. Generally, there's the idea that users or people, or in our case, students, who are subject to data collection should be notified of that fact, and they should be able to, that should be transparent. Next is the ability to opt in and opt out, that they should be able to consent to having their data collected, and sort of in more modern times also to how it is used. The access and amendment part is that users should have the right to access the data about them and the opportunity to correct them or challenge them if they don't think they are accurate or relevant. And there's security, which is trying to prevent unauthorized access to records, and also making sure that there are systems in place both technologically and procedurally and sort of in terms of personnel to protect information. Also, governance. That's just general, that's really undefined, but generally having good practices in terms of how things are stored, and also within institutions, making sure that information is only seen by essentially the relevant people on a need-to-know basis. So these acronyms are things that lawyers love, so that's why they're there, and they're also shorter to put on a slide. But here's a timeline in terms of how they were developed. Concerns about privacy and user privacy in terms of data really originated in the 1960s with the rise of the computer and the possibility of digital databases. At that time, there was also in higher education increasing expansion of services beyond academics to students, and overall there was really pressure about how data about individuals was being used. This was initially dealt with in the Federal Fair Credit Reporting Act, which, as I'm sure most of you know, limited the things that could be considered on a credit record, credit score, and ensures, again, access and amendment rights and transparency. So you can check your score, you can challenge it. Presumably it's held securely, although with Equifax that may be in question at the moment. And essentially, we don't expect people who are making the scores to just be handing it out to everyone in their institutions. That there was also a rise in concerns about student privacy for several reasons. One of these was that with all the protests student protests that were going on at the end of the 60s and early 70s about civil rights, about the Vietnam War. Schools and sometimes they would keep lists sometimes of students who were likely disruptors and would occasionally share this with law enforcement and the FBI. There was also concern on the other side about schools collecting intrusive information about students and having this information be inaccurate or biased or completely irrelevant, and having this information in student records in ways that might foreclose future opportunities unfairly. So there was a lot of scandalous stories told around that time. You know, for example, on the K-12 level, one student hugging another student and then being written up as a potential sexual predator later in life. Many of these concerns are really focused on K-12 in terms of that this sort of intrusiveness factor of it. So Hugh was what was now the Department of Education was in Hugh, and they came out with a report in 1973 that outlined the first version of the Fair Information Practice Principles. These were then incorporated into FERPA, the Family Education Rights and Privacy Act. As you are no doubt aware, FERPA is the primary tool on the federal level that ensures student privacy and deals with student data in higher education. And then this was then continued to be incorporated into, as the FIPPs became the model for basically all of our privacy laws and many European laws. And particularly you can see them being used in the consumer space. And right now that looks like privacy policies online. So that when you use a website, that is providing you notice and transparency. You are consenting by continuing to use the site because most of those policies say that you're using the site is considered consent. They're presumed to hold things securely and use good government. And that is how, right now, the sort of ideas of notice and choice, access and amendment, and transparency play out in the modern context in terms of the digital environment. So the dominant, this is now sort of the dominant approach to online privacy. It's the idea that users, students have the ability to control who can access their information and have some ability to monitor whether that information is correct. So in this case, it's voluntary enforceable privacy policies. That's what I just discussed in terms of consumer websites and other online platforms and apps. So here is FERPA specifically. And FERPA embodies these in the FIPPs in several ways. As a baseline, as a default, it requires schools to have parent consent, or in this case, students' consent, because we're in the higher education context, before they can disclose personally identifiable information. And that's maintained in a student's educational record. Of course, every single one of those terms has very specific regulatory and lawyer definitions, but for today, I'm not going to go into those. Just in terms of that, for FERPA, the importance is also that, as you are also no doubt aware, there are many exceptions that sometimes swallow the rules, especially in higher education. Through the school official exception, higher education institutions can essentially consent on the behalf of students, and this is what allows schools to disclose information with vendors who might provide student information systems, learning management systems, and really people who provide facilities, operations. It all happens under this school official exception. And in that case, the school is supposed to ensure that, broadly speaking, that the information is going to be used for a legitimate educational purpose. and that the recipient is appropriate. So when FERPA was first passed, it was 1974. And in that case, most school records were held in paper. They were in filing cabinets on school premises. And to disclose information requires a conscious, voluntary act on behalf of individuals. So this would mean handing a file to someone who asked, mailing a transcript to a college, or answering a phone and answering questions about a student. It worked sort of for these purposes in several ways, in part because until recently, schools could only hold a certain amount of information, and that was predominantly academic and administrative, and some standardized test scores. And then also, you couldn't move around the data around much. They were physical, and they could not be shared or, importantly, extracted and then aggregated or used in research or evaluation in terms of looking at trends or outcomes or what choices or decisions or policies relate to certain outcomes, either at the aggregate or the individual level. So then the cloud and big data changed all of this. And now we have data about individual students that resides on servers and that schools access and can share, often through interoperable APIs, and do whatever they want with. This is important for several reasons. And one of them is when it's on the cloud, there is different opportunities for sharing. Obviously, it's easier. It can be instantaneous, but also security problems. Once you're in a network, it's possible for individuals to hack in, possibly, or what is more common, for people within an institution to simply make a mistake, but instead of that mistake, meaning you might hand a document to the wrong person, everything gets emailed to people on a list or accidentally posted on the internet. And big data, in this case, there are technical definitions, but right now, I'm talking about it in terms of having large volumes of data that can be analyzed statistically to find certain patterns and predict occurrences. This can be used in academic analytics, for example, predicting degree enrollment, and it can be used in specific learning analytics, determining whether a student is likely to pass a given course or what information they may not be understanding. And it's also used for advising and guidance and early warning systems in many institutions that will alert advisors if students are displaying behavioral patterns that suggest they might be at risk of failing or dropping out. And in this case, the information I'm talking about includes non-academic data that could be drawn from social media, the information that students reveal when they use ID cards to pay for things or access facilities, and a variety of other information. So data-driven education is what we're talking about, and it really has changed the game because we now have programs that not only use data to drive institutional choices and matters, but the learning process itself. Whether you call these MOOCs or virtual learning environments or e-textbooks, data is everywhere and is collected through activity streams. So not through activity streams. The clickstream data that shows what students do with a platform and what they input into the platform. So it may show when a student pauses on a mouse, whether they answered a particular question wrong, how much of a video they watched or a chapter they read and what they highlighted. This information is tremendous and is tremendously valuable. It's also quite detailed and can be used to infer lots of different things about students, which might be illuminating, but people also sometimes see as evasive. You might, for example, use information about when students log in or not and how much they watch of a video and their mouse movements to infer whether a student is engaged in the material or not. So this raises concerns about surveillance and when it is appropriate for institutions to be able to collect information. What is important to note is that the FIPPs do not address this other than the opt-in, opt-out choice. They don't have anything that differentiates between what institutions can do once students have given their consent to collect data. So in the digital era, the FIPPs are not as effective as they were in their paper records for several reasons. And when I say not as effective, I mean not as effective in addressing the concerns that really prompted them in the first place, which is about accuracy again, outdated information, irrelevant information, unauthorized access, inappropriate disclosure, and disclosing for purposes that are not educational and might be commercial. So the automated collection disclosure, which I just discussed, is one of the primary reasons that FERPA and the FIPPs that are at its core do not work as well as they did in the past, and many see is not sufficient in today's era. The idea of giving consent to certain information being shared, for students to give that consent, or for schools to consent on their behalf when they're sharing information with outsiders and vendors, worked as a way to ensure that there was oversight over disclosure and subsequent use, because someone had to voluntarily do that, as I said before. Once you can collect information from a clickstream and there are multiple vendors and multiple sources and multiple actors at all levels, and information can be collected passively without the user's awareness and without the institution's awareness. That means that the oversight FERPA provides is minimal at best, and the consent is really in one giant chunk. Either you're okay with how things happen, or you can't do it at all. The transparency paradox is the idea that even though people know about privacy policies, they're difficult to read, and including institutional policies as well as the ones on commercial websites, and often people may give up information and consent to its collection and use, even though they feel uncertain or hesitant about that. Re-identification is an issue because by combining various data sets, data that was anonymized and therefore was outside the sort of scope of FERPA limitations, re-identification is very possible nowadays. You simply have to combine a few data sets, and it's very easy to re-identify who a particular student is. Even if you don't know that student by name, you can identify a particular student and their learning path and activity and access their records. This relates to the FIPPs because the FIPPs apply to personally identifiable information, and anonymization was the primary way that you could then not have to worry as much about the FIPPs. But now that is more difficult. That is also more difficult in education environments because we specifically want to track individual students and know who they are and track them at the student level. Otherwise, you really reduce the utility of the information. In terms of FERPA, it only applies to federally funded education entities, which includes higher educational institutions that have students who are on federal aid. That does not address concerns about what vendors are doing with information that students might directly share with them that aren't through schools or universities. The nuclear enforcement is the idea that FERPA has the very strong enforcement mechanism of withdrawing federal funding. That's its primary enforcement mechanism. And of course, doing that would hurt the students that FERPA is designed to protect. So people often describe it as a nuclear option, something that the Department of Education will not ever actually pull the trigger on because it's just too damaging. And lastly, FERPA's protections and the FIPPs are predominantly procedural. So it's about notice and consent and access and amendment, and these don't get to specific issues that are harder and more substantive, like what information is it okay to collect? What is appropriate for people to do with the information? When should the information be deleted? These are questions that are more difficult that many people feel were not adequately addressed by FERPA. So this is the kaboom slide, which is meant to represent around 2013 the explosion of information that was being provided to the public about the extent of data collection in schools. And in this case, also In Bloom's explosion. In Bloom was the very well-funded Gates Foundation backed data repository that promised interoperability and greater security. Due to some conflation about so there was a lot of misinformation and misunderstanding that led to In Bloom's downfall. People often confused it with the Common Core, and as an instrument of the Common Core, people conflated it with standardized testing, and there was a lot of misinformation about what In Bloom could do with information apart from things that would be directed by schools and in terms of selling information to others. In Bloom did not help matters because they didn't launch with a perspective eye to privacy considerations. It was more about the amazing things you could do with more data and more data sharing. And this came off to the public and concerned parents in particular as being cavalier with important information about their children. So this brings up a few important considerations about privacy and fair information practices that are different in education in terms of instead of other contexts like consumer or medical. There is the consideration about surveillance. People sometimes worry that knowing that they are watched will chill student expression and speech, will mean that they articulate more mainstream viewpoints, and that will undermine the academic freedom of professors to say what they want and take alternative, perhaps minority viewpoints. There's also a competitive pressure to opt in. So while higher education is not compulsory, in many cases, the choice to opt in or opt out is not a practical one for many students. Few students would choose their institution on the basis of its privacy policies and practices, as opposed to other important things like the location or caliber or financial aid they would receive from a school. And many don't want to opt out of whatever schools are doing, even if they could, because they think they won't get as good of an education, or that employers might say, why don't you share this information? Do you have something to hide? And then we put it at a disadvantage compared to other students who decided to opt in. And lastly, there are the high stakes. Now, as students are repeatedly told that a college degree is the key to future employment, both in terms and where they go to college is also important. And that means that anything that has to do with data that might affect those choices or options and the career and life and social success that leads from them has really heightened importance and often leads to a more emotional reaction by people. this is more true in K through 12 education, but it's still quite true in higher education as well. So here are some common concerns I've touched upon, but I wanted to highlight them again. So there's surveillance, there's the inaccuracy of certain data, there's data that is outdated, there's possibly data that is biased, and this is partly coming from research that has shown that data analytics do not necessarily create neutral results, but because they're often based upon history and patterns that are due to structural and economic inequalities. When they are predictive, they often suggest things that also have the same discriminatory patterns built in. For example, 30 years ago, if you had a predictive application that was making admission choices for people who had applied to be physics majors, it would predict that the people most likely to succeed would be white men. And that was due to a lot of reasons, which are not necessarily related to the inherent ability of people who are not white men to succeed at physics. People are concerned that there will be stigma with their peers, but also in terms of teachers and perhaps priming teachers to underestimate their abilities or skills. There's a concern about information being repurposed for commercial, sort of being sold or used for, let's say, Google as an example. If information collected on Google Apps for Education would be used in other Google products. And additionally, sometimes for research as well. There are the federalism concerns. Often, policies about student data become a battleground for people who would like a more centralized and federal approach towards governance of education, and those who prefer a more local or state approach. The concerns about persistent labeling and creating a permanent record. You know, people are quite concerned that you will trap students and really limit their opportunities based on mistakes they've made in their youth, which people often consider college years as part of that trial and error mistake-making process, where we don't want to hold students completely responsible for things they do that within a few years they might not consider as wise a choice. So here are some privacy-enhancing possibilities that institutions or policymakers can take that help with some of the problems that people are having with the FIPPs in the digital era. One is to choose to minimize the data you collect or retain, often to information that is really just immediately useful. The problem with this is that often there's the desire to collect as much information as possible under the assumption that this will give you more accurate results, more precise results, or that it might be useful in the future when technology develops or people have new systems in place. It's also difficult as we're moving towards a world where there are sensor devices everywhere. So cameras, security cameras, audio recording in classrooms. When these things become prevalent, it's very difficult to minimize the information you collect, although you might be able to minimize what is retained and kept. Student choice is a way that people often think is still very important as a way to preserve students' sense of autonomy and respect for their privacy. As I mentioned before, it is often difficult for students to choose to opt out of a system, but this is exacerbated if it is presented as a fait accompli and they are not made aware that they might have a choice in particular ways. This might mean the ability to have certain aspects of data collection in schools or for reporting purposes or sort of secondary purposes. Some of it be mandatory, the things that are deeply essential, and some of it be optional. For example, students might be required to share information that is collected through the school's learning management system as they interact with Blackboard. But they could conceivably be given the option as to whether this would be used in an early warning system that would alert advisors based on their patterns. It's also difficult to do, but I think quite important for schools to consider what they might do if students do want to opt out of their data collection and uses, if there are alternatives they can provide. And some of this, again, may be in terms of collection, use, or retention. Purpose limitations is how many states are currently approaching privacy in a post-FIPPs era, as well as the Commission on Evidence-Based Policymaking. In the state level, many K-12 laws limit data use that might be held by schools or vendors that they share information with to what are predominantly conceived of as educational purposes. The Policy and Evidence-Based, the Committee on Evidence-Based Policymaking has recommended possible an analogous limitation, which would limit use to statistical purposes, essentially limiting the use of information that might be collected in, say, a federal student unit record, which is currently banned, but if it was overturned, that information could only be used for certain research purposes. I always tell people to never underestimate the value of communication. It is important to communicate with students and the community and other stakeholders what you are doing with their data and why you are doing it and how this specifically benefits them. Many people hesitate to do this in detail because they're afraid it will set off privacy alarm bells and create a backlash. But in my experience, it is much, much better to have potential short-term, minor disruptions than large-scale revolt, which leads to things like In Bloom being shuttered. And it also leads to really reactionary, ill-advised and ill-conceived regulation. For example, Florida's ban on collecting biometric information, which led to the difficulty of their complying with special needs requirements. And lastly, community. It's important to consider these issues in terms of the educational and institutional community, not just about students, but also teachers and staff and administrators. And that is my current summary of the Federal Information Practice, the FAIR Information Practice Principles. I hope that's given you a good overview, and I'm happy to answer any questions you might have.
Thanks so much, Elana. That was very useful. Anyone can go ahead and unmute themselves in Zoom or put questions in the chat box. We'll pull that up to see if we get any. In the meantime, Elana, yeah, I know before this call we had talked briefly about sort of the College Transparency Act and the Commission report. What would you say if, you know, as many people in this group are, you were advising congressional staff on how to build in more privacy protection?
Wow. So the first thing to say is that this is an extremely emotional issue. The student unit, the ban on having this detail of collection in the federal government was, as many privacy policies are done, made in part in reaction to misinformation and fears, and in part because of the way that data collection interacts with educational policy. People saw not only that this would be privacy a problem in terms of privacy, but that it would give the federal government more control over what happened in local and state schools. It leads to the kind of conversations that we saw around the Common Core. So that's the first thing to understand. It also is important to understand that the people who don't like the idea of this kind of record see it as the literal embodiment of the permanent record. Lastly, you have people who are skeptics of the federal government and their ability to make good analysis of things, make good decisions, and keep information secure. So that is those sort of hurdles that it's important to consider when approaching policies about this. I would say that while I would say that good intentions are not enough in this circumstance. Often people who want to collect more data and do more with data have the best of intentions, but that does not actually mean that people are less concerned about all the things I mentioned in terms of what might happen with their data. And that's because you can have these problems even if information is used for educational purposes. You might have heard of the famous example of Mount St. Mary's, where the dean was collecting information about students to predict which ones might drop out over the semester and encourage them to drop out before he had to report his enrollment, which would ultimately affect his retention ratings. That is ostensibly an educational purpose. That does not necessarily make people feel better about what would have happened to those students had he been able to complete his plan. So the first thing to say is communication with stakeholders is essential. It's also essential to demonstrate that you acknowledge their concerns, that you don't consider them to be radical, crazy people, and that you are doing something to address their concerns. This may mean initially limiting some of the things you can do with data or the scope of the data you collect, giving students more choices in terms of opting in and opting out. And the procedures I mentioned sort of here. These are certainly ways that you might advise congressmen and women to go. To sometimes maybe reel back their ambitions and take things one step at a time, because having some information at this level is probably better than none. And especially datamization, student choice, purpose limitations, retention limitations is also a really big deal and underutilized possibility. Maybe you only want to keep information at the personal level for a certain period of time. So those are suggestions in terms of how you might be able to sort of assuage people who are concerned about the consequences of a sort of federal data system. And also just another thing to mention, which is people are also concerned about how one of those systems might be connected with other federal administration and agencies like criminal records, public welfare, labor data. And while this could be extraordinarily useful, people are really worried about a system where something you do in education might affect your welfare status, or somehow something interaction between the criminal justice system and data collected from education might either lead to more incarceration or improper incarceration, or on the other hand, having students' education prospects being hurt by, say, juvenile criminal records. Those are things I would think about.
Great. I don't see any chat comments, so I will continue with my own. Oh, there we go. Question from Amanda. Should we expect an update to FIPPs if FERPA is updated?
Oh, good question. Probably. I don't think it's going to do much good, though. That is my very broad and off-the-cuff sort of idea. So the FIPPs, in terms of FERPA, places a lot of burden on schools. So schools are expected, sort of the school official exception, to do all the vetting of the people that they share information with, what they collect, how they use the data, how they retain the data, how they secure the data, and also to have, quote, direct control, quote, over that information. This is really difficult for schools to do. Many don't have the resources or the technological sophistication to do this. And right now, the burden is on the schools, not the vendors, to get that information. So often I tell people, if you want things to work that way, you should create a requirement that helps vendors, who are the people who know what's happening in the system, be able to better communicate with schools. I also am not sure about transparency and notice, for the reason I articulated earlier, that we all have data privacy policy overwhelm. We all basically click on the terms of services, in part because it's hard to understand, but also because we often have no practical alternative, and most people will want to use the cool Google app or get onto Facebook. I think one way that might be interesting to see what happens is with an access amendment, because this also right now is very impractical. There was an instance where a Nevada father requested his child's records, I believe from the state education agency, which he has a right to do under FERPA, and they said, we don't have the money to do that, because that would require us to create this system and machine. At this point, those systems and machines should probably not be hypotheticals that aren't being thought of as being put into existence. So I can't predict what will happen. I think increasing the FIPPs in terms of transparency and notice and a little bit of choice and the opportunity for access and amendment is likely to happen, but whether that makes an actual difference in terms of how well protected people think their information is in terms of privacy, and whether it addresses their concerns about things that happen for educational use of data, I'm uncertain.
Thanks, Elana. You touched on this a little bit, but can you delve in, what else is beyond FIPPs? What are some of the suggestions that we're seeing, not specifically in education, but in the broader privacy community's conversations about what will replace FIPPs?
Oh, good question. So some of these involve transparency on the level of algorithms and algorithmic decision making. These are prompted from studies that show that algorithms can create biased results or have disparate impacts on different subgroups. So there's a very lively discussion in the tech policy and law community about whether you could create applications or systems that would make it easier for either companies or policymakers or school administrators and teachers to see what's going on inside the black box of algorithms, and or being able to test whether or not they are having disparate impact on different groups over time, and also whether they are effective. But beyond that, there is more and more consideration of use and explainability. Some of these are modeled after the privacy regulations that are in Europe, which are deal much more with taking a precautionary stance and the use of information and substantive privacy ideas, and not the procedural ideas that really are the approach that FIPPs take. So this might, things I've heard that are mostly borrowed from the European context would be having, again, a right to explanation in terms of why certain decisions were made, having restrictions on use for particular purposes, commercial or research, and especially ones that don't seem related to the immediate provision of whatever service there is, or in the case of a unit record, the analysis of what is immediately at issue, and not creating some large web that tries to incorporate, welfare and child services with educational information. And data minimization in terms of restricting what can be collected, but substantively in terms of not like actual categories that companies or institutions should not be able to collect. So those require more difficult choices than the FIPPs, because you do have to draw a line somewhere. And of course, some people will be unhappy about that, whatever direction you choose.
Great. Again, anyone can put questions in the chat box. I know Elana's given us a lot to think about. Elana, on the transparency side, can you dig in a little more on examples you've seen of more successful transparency being provided?
One thing, there are a couple things that are great. Some are disclosing who schools share information with and what the broad purpose are for that is, in terms of what the data is used for, in terms of provisions that support the either educational institution or student learning or trajectories in particular. That's something that gives people some sort of security and idea of, again, not only about the specifics of what's happening, which are probably going to be primarily looked at by a few students and a lot of advocacy groups, but also to demonstrate that schools are aware of these concerns and they are trying to do something about it. And the idea that if they were doing something bad, they wouldn't really be able to disclose it. So that leads to the converse presumption that if they're not sharing, they might be doing something bad. So, what information you're sharing, what information you're maintaining, what information professors can use and see, that is really important. Most students don't know, and schools have very differing policies on whether professors can see how much of a video you watched and what time you logged into the system, or if you logged into the system at all. So being very clear about what the policies are in place and the protocols in place are important. And also, very important is to have a place where that is very transparent in terms of very visible on the website or in materials you give or on the learning platform, places to be able to ask people questions about what's going on. So I'm concerned about this. Who do I talk to? Or I think there might be wrong information about me here. I don't know what to do about that. Having a path, even just if it's an email address that people can use to ask those questions, either students or teachers, is supremely helpful.
Fantastic. We have another question in chat. Have you seen a clear distinction between K-12 and higher ed data concerns and how they are addressed in policy, either state or federal?
Yes, there's a clear division. People are much more concerned with advertising when it comes to children, K through 12 level. They're sometimes more concerned about the retention of records because they see things that happen earlier in life as less relevant to educational or career futures. They are worried about juvenile records. They have more of a sense of concern about for-profit entities being able to access students' information. There is more concern about data collection of schools being intrusive, for children who have free lunch or have special needs. And a lot of those concerns are not only in terms of ultimate career paths, but what might bias teachers in an institution against students before they even start, which of course can be turned around to what teachers might know about students that could help them. Also, the surveillance aspects. And there was one other that I just forgot as I was talking, but perhaps it will come back to me. So these are predominantly handled by purpose restraints, and data minimization and data collection restraints. So you can't collect this. You can only use or disclose information for what is broadly considered an educational purpose. Companies can't create a profile for distributors. In K-12, there are a lot more regulations that are aimed at the companies that provide information as opposed to just the students and the institutions. And they do have more substantive limitations. One thing, though, to keep it in mind is I don't know how strong that the difference is, how strong. So I think there are a lot of concerns in K-12 that make people very emotional. Parents are very protective of their children, whether you think that is correct or wrong. And in many cases, it is actually quite rational for them to be concerned, since education is a high-stakes enterprise. So being perhaps overprotective is quite rational, even though it doesn't seem like it is to people who are trying to use data in a well-meaning and responsible way. But I think that many of the considerations people have in the K-12 space do apply in higher education as well. There's the idea that once you enter higher education, in terms of at least the law, like FERPA, you magically become mature and responsible for your data management, and you self-manage your data. And also, more to the point, that the things you do, we're more comfortable putting them on a record that might last a very long time. While we do this, I think there's still a sense that college is a place where people are still experimenting and maturing, and we may want to buffer them from outside consequences that might occur as the result of data use and collection. Higher ed, there's also more of a concern about academic freedom and possibly chilling alternative viewpoints.
Thanks, Elana. Another question, opt-in or out has come up in the context of the College Transparency Act and the creation of a student unit record system, specifically whether consent is required or not, or if not, whether it is desirable. What are your thoughts on student consent and FIPPs here?
Good question. There's pros and cons. I think a big pro is that people who are concerned about the possibility of federal records, being able to opt out really eliminates them in terms of the opposition for something like that to pass. I mean, people might still have problems with it conceptually, but they themselves will not be what they would consider subject to that collection and use. That gives people a lot of choices and the idea of autonomy, and that goes a long way when it comes to privacy. The downside to that is it will mean data sets are skewed and less complete, which is also a concern. I also think that various institutions may have differing approaches to whether or not they consider it okay to share that information with the federal government. Oh, and something I should bring up, which I actually haven't addressed yet, is one major issue here that I do not think is addressed enough in the policymaking discussion is that people are very concerned with this information being used for accountability purposes and funding and teacher evaluation and hiring and college ranking. that it's not just going to be used to study things that happen and perhaps make more informed choices, but that it's going to be held against the teachers or institutions that are providing the information in the way that some people object to the value-added scores for teacher promotion and hiring. But I do think giving people a choice, if you don't give people a choice, they will get angry. And you will certainly see people ranting about it online. You will still see that if you don't give people choices, but I would think very carefully about providing opt-in or out I would think very carefully about it as something that might increase the possibility of something like this passing and being accepted by the public.
Thanks, Elana. All right, well, we are pretty much out of time unless there is any final questions in the chat box. Give it just a couple seconds. Doesn't look like it. Well, thank you so much, Elana. I will upload the video from today's webinar and share it with Amanda so she can send it around. Thank you to all of us who joined.
Oh, sorry, and also,
yeah,
sorry,
go ahead.
Feel free to, anyone, I know many of you on the line, and if I don't, feel free to reach out. This is what I spend my entire life thinking about, so I'm usually happy to have people ask me questions.
Awesome. Thank you so much for that, Elana. Have a great rest of your Monday, everyone, and I'm sure we will all talk again soon. Thanks so much.